now a training module,
Perfect.
right? Like all the videos, all the prep, like it's like that presentation with a little bit of adjustments is a training module.
It doesn't like this one either.
It doesn't?
No.
Mentee, get it together.
It's too bad. If we have to drop it, we gotta drop it.
Okay. And I was
I'm
gonna
wondering-
say,
We got time still.
I'm wondering if the mentee,
actually here, I'm just gonna
can it be
reset.
shared?
I'm gonna try that, so I'm gonna
My
reset.
audio's good.
Your audio's good?
Yeah.
And did we try playing one of the videos and the audio works good on that?
No, okay. Put this one on
You
the
do
left
whatever
and
you
not-
gotta
She's
do.
like,
It's all good. I'm like, what?
Still
Oh,
working
you're
on
talking. something's broken. All right. Here's one.
Witnessing a power of attorney. So just like the will, powers of attorney do not legally require notarization. They just need to be witnessed by two individuals. Those people should not be named in the power of attorney. They should not be your family members. They should not be your spouse, and they must be over the age of 8.
Great.
Nope. Awesome. Good evening, everyone. My name is Jaclyn, and I'm the chair of the OPA's Education Committee and your moderator this evening. On behalf of the panelists and the OPA, I would like to welcome you to tonight's CPD, Notary Public Responsibilities and the Shift to Online Notarization. We first acknowledge that as treaty peoples, we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples. We also respectfully recognize the enduring presence of all First Nations, Inuit, and Métis people on this land. Tonight's program will provide an overview of what a notary public is and their responsibilities, practice management tips for properly notarizing a document, whether it's in person or virtual, and ensuring notary publics comply with the necessary professional requirements. We are very lucky to have a team here from Notary Pro today, including Robert Onley, Jaclyn Rose, Danny Waugh, and Talia Wang to speak to us on this subject. And now a little bit about our speakers before we begin. Robert is the founder and CEO of Notary Pro. Founded in 2016 as a side gig, he grew the company from a one-person operation to over 210 notaries and counting. Robert oversees the strategic direction of Notary Pro and provides guidance and advice on the legal and regulatory environment that Notary Pro works in. He has a JD from the University of Windsor and lives in Toronto, Canada. Jaclyn is a licensed paralegal with the Law Society of Ontario. She graduated from George Brown in paralegal education and received her license and notary public appointment in 2019. She is the notary team member with Notary Pro and assists over 200 notaries with all their questions. Danny is a first-generation immigrant born in Malaysia but raised in the quiet prairies of Alberta by his humble Vietnamese mother. Having learned from the best, he landed all kinds of odd jobs and then ended up in Ontario where he was licensed as a paralegal and joined the Notary Pro team as their online notary expert. When he isn't helping clients with their documents, he reads self-development books. Talia is a licensed paralegal with the Law Society of Ontario. She graduated from Centennial College in paralegal education and received her license and notary public appointment in 2020. Talia is Notary Pro's international document specialist. Welcome, everyone. We ask that you keep your questions to the end of the presentation, while we will address all of them at that time. And I'm very excited for tonight's program, and so without further ado, I'll pass the mic to our presenters. Thank you again.
Thank you, Jaclyn. Thank you, everyone here in person and online. It's really a pleasure to be with you. So my name is Robert Onley. I'm the founder of Notary Pro. We are, as mentioned, a national network of notary publics and commissioners. And our membership, our notaries, are primarily lawyers and paralegals. And I'll talk a little more about that in a second. I want to thank the Ontario Paralegal Association. I want to thank you, Jaclyn, for helping us get this organized. And it's really a pleasure to be here. So I wanted to share a little bit of background about Notary Pro, and then we'll jump in and I can explain a little bit of what we're hoping to accomplish tonight. As a little bit of context, so I graduated from law school 10 years ago from the University of Windsor Faculty of Law. And at that time, when I first started out and was called to the bar in 2013, I had really no idea what it meant to be a notary public. And I had no idea, truthfully, what a notary does or what a commissioner does and what the differences were between a notary and a commissioner. But pretty quickly, when you start out in the practice of law, someone will come to your door and say, hey, can you notarize this document? And so you pretty much have to learn on the fly. And from that moment on, when the first person who asked me to notarize a document, I did some research and I started figuring out what it meant to be a notary public. And what I would say, and this is sort of with the benefit of almost 10 years of hindsight, is the law schools in general don't really train or equip you on how to be a notary or how to be a commissioner of oaths. It's just not simply part of the curriculum. And so as I started out my practice, I recognized that there was a gap both in the marketplace for notary public services as well as a gap in the training for legal professionals. And so flash forward a number of years, Notary Pro is operating across Canada. We have an online notary service platform and web app. And our mission fundamentally is to simplify and humanize notary public, legal, and paralegal services. And we do that a number of different ways as an organization, but primarily what we've done is made it really simple and easy to both find a notary, meet with a notary, and then pay the notary for services. So we made everything as accessible and as transparent as possible. And why I bring that up is Notary Pro today in late 2022 is actually the majority of our network of notaries are paralegals. So we have over 110 paralegals in our network. I think we have another 10 or so that are being onboarded currently. And so it's really exciting for us as a company, which is now 14 employees, and we have some, well, all over Canada, really. We're a remote first company. But on our staff, we have 4 paralegals. Full-time, I should say, 4 full-time paralegals, and then 4 part-time paralegals. So as an organization, we've really become, the majority of our professionals providing services are paralegals. So it's really been an interesting shift in the last 2 years as we've embraced hiring paralegals who only recently in August 2020 could be appointed as notaries. And so it's been an exciting couple of years, and off camera here are 3 of our staff members who are also all licensed paralegals and notaries. And so we're really excited for them to present. I mentioned kind of the gap in the training regimen, and so for paralegals in particular and for lawyers, but it really is something that you learn on the fly, and you kind of have to learn when someone comes to your door and asks you to commission a document. And oftentimes it's family or friends. But as part of Notary Pro's mission, what we are doing more and more is actually training, educating, and equipping paralegals to be ready to be commissioners of oaths and notary publics. So that's become a core part of both our day-to-day operations as well as our overall mandate. It's now training notaries and training commissioners. So we're really excited to present tonight, and I hope that anyone watching can learn as much as possible here. We hope this is the first of several opportunities to provide training both in person and virtually. So I just want to thank everyone here and online. And with that, I can happily introduce our notary team manager, Ms. Jaclyn Rose, who's going to be talking about the role of the notary public as well as how to notarize some of the most common documents that clients will bring to you. So thank you very much.
Hi, Hi, well, thank you everyone for having me here. I am Jaclyn, a paralegal, notary public, and the team manager at Notary Pro. So what is a notary and what do those roles include? Notaries date back to ancient Roman times. In Canada, the powers of notary publics are set out by provincial legislation. In Ontario, lawyers and paralegals in good standing with the LSO are able to be appointed as a notary public. You just need to submit your application, pay your fee, and you are good to go. This is a lifetime appointment in Ontario. The difference between a notary and a commissioner. So a notary public can do all of it. A commissioner can do less. They can only do documents that you would swear an oath. A notary public is a commissioner is unable to do like a certified true copy. So if you're a notary public, you can notarize all of the documents. Checking ID, obviously this is one of the most important parts of notarizing. You want a government issue valid photo ID. You are not allowed to request a health card. You are allowed to accept a health card, but if you do record that for your records, you must redact the number. Always check the picture, make sure it matches with the client. Review the signature on their ID and make sure that's the same signature that the client is signing. Confirming the document requirements. Where is the document going? Has the client filled out all of the gaps? Are the dates correct? That type of thing. And then obviously the supplies needed would be pens, stamps, seals, and we also recommend like a square reader or a POS system. Understanding the jurat. So this, get familiar with it. You're going to do this all day, every day. This one in particular is drafted for the states. This will also come up often. So you are permitted to just scratch out the word state, write province over it, initial it, and continue on. Okay, so now we are going to do a Menti question. I'm gonna ask everybody to please take out your phones and go to the website, type in the code.
People online can do it too.
Oh, yeah, and online, go ahead, you're allowed to vote as well.
Do you have a question?
Sorry, guys.
It's all good. Let me help you. Here we are.
Has everybody had a chance to answer?
Yeah.
Oh, still getting some more.
Explain it. Yeah.
Okay, so the answer would be D, because it is always best to throw all the stamps on a document, especially if a client has drafted it themselves. So the sworn before me stamp, obviously with that, you would use your oath, your verbal oath, and then seal the document as well. So good job, everybody got it right. Thank you. All right, so now we are going to discuss seals and stamps and their differences. Stamps you would use to avoid having to rewrite the same text repeatedly, and seals is your embossing seal or your gold stickers. You could also get a ink seal as well. Those are great for when you're scanning a document. I will say most clients are looking for the embossing seal. Embossing just is a fancy word for making your paper all bumpy. They are all equally as acceptable. One is not better than the other. Oh, and then we are going to watch a video on a seal-only document. Here we have an RCMP fingerprint check. This document's a little complicated in the sense that it's not glaringly obvious what you as the notary need to do. Always, you would verify the client's ID, and then you can go ahead and use your name stamp. Find a nice big blank section on the document. Stamp your name, sign it, then date it. And then you go ahead and seal it. So really what you're doing here is just showing to the recipient of the document that you have verified the ID and everything is accurate. Okay, so now we are going to dive into the differences and each stamps. These are the stamps that we would recommend. So first and foremost, this credential stamp or name stamp, whichever you want to refer to it as. It must have your full name that's registered with the Law Society. We also recommend always adding no legal advice given, especially if it's just a pure notarization. Obviously, if it's one of your clients, you don't have to use that stamp. The sworn before me stamp, it's going to be one of your most commonly used stamps. You use it in addition to the verbal oath. Examples would be letters, affidavits, statutory declarations. The seal, your embossing seal, is not required when you're using this. This would be a commissioner-based document. However, it will not invalidate your document. You can go ahead and seal it in addition. So this is the oath that we recommend using. Do you solemnly swear or affirm that the contents of your document is true to the best of your knowledge? Obviously, if the client says no, you run for the hills. Here we have a generic affidavit. They are quite common. You'll notice the jurat has been drafted for both in person and online. So you just check the applicable box and fill it accordingly. You will then ask the deponent to swear that the contents of their affidavit is true to the best of their knowledge. After you've checked their ID, of course, the deponent would then sign their name. You as the notary would then sign your name. And then you would stamp and seal the document. So here we have an invitation letter, very common document. Of course, like always, you would first verify the IDs of the people that are signing the document, ensure that the date is correct, ask the client to review the document to ensure that their personal information is accurate, there's no typos, and then you can go ahead and have the client sign their name after solemnly swearing that the contents of the document is true to the best of their knowledge. Now, this could be a joint letter. For example, a couple could be inviting somebody to come visit them, in which case there would be another line for the other person to sign. And then I like to use the sworn before me stamp. This stamp is good to use on documents that don't exactly have a line for you. Some invitation letters could have the notary public line. This one does not, so we'll use the sworn before me stamp. You would then obviously fill it out. Sign, and then you would also use your name stamp, and then you would go ahead and seal it. So now we're going to go on to certified true copies. I would recommend being very careful with these documents. It's frequent that people will come in with somebody else's document and ask you to certify it as a true copy. even though they're not named on the document at all. So for example, like a marriage certificate or a high school diploma, and they're like, oh, I just need you to make a certified true copy for my friend. We'll ship it over. I would not recommend doing this unless you have a consent letter, and I would also recommend a video phone call during the appointment, just because you don't want to be, giving out diplomas. And then we can go on to a certified true copy video. Now we're going to do a certified true copy. So that's typically of a driver's license, passport, could be a high school or university diploma, whatever it may be. So the client would bring the original. In this exercise, that's the Presto card, as well as a copy. Colored copies are always recommended. So that's when you would take the original and you would compare. All right, these look accurate. In the back as well. Yep, those are accurate. And then you can go ahead and use your certified true copy stamp. And that's when you fill it in. So I like to write my name so people can read it. And then go ahead and sign next to it. Obviously add the date. And then I also like to add my name stamp to that as well. And then go ahead and seal it. Another Menti question. How exciting. Confusing. So the question is, a client brings in an affidavit that mentions Exhibit A and B. They also provide a notice of assessment and a text message. Which stamps do you need to use?
Jaclyn, can we go back a slide for the code?
Here's the code.
Sorry.
No problem.
It's like everyone's a wizard tonight.
All right. Well, it looks like you all got it right, so yay! Okay, so now we are going to speak about witness-only documents. In Ontario, wills and powers of attorney do not legally require notarization. They just need to be witnessed by two people that are over the age of 18, not mentioned in the will, not the spouse of the testator, or a family member to the testator. I would recommend that you take extra caution when you are notarizing these types of documents, as they are very powerful. People can be signing over their entire life assets to other people, so err on the side of caution. So there are 3 different types of powers of attorney. There is a power of attorney for medical-based decisions, which would be a POA for personal care. There is a power of attorney for property, which would, for example, go to your bank. And then there's powers of attorneys for specific situations, and that would outline what exactly you're allowing the person to do and for how long. Wills and powers of attorney can also be notarized in counterpart online. You, as a legal professional, are able to offer this. A layman's person, someone without any legal training, would not be able to do this. So you have to be licensed with the Law Society. You would print out a copy of the client's document. They would have their documents. You would meet virtually, and then you would both sign with wet ink. And then you would snail mail the document back to the client, and when they're put together, it would be legally binding. We also recommend using affidavits of executions with your wills. Each and every estate that goes to probate court will require an affidavit of execution. It can be very difficult to track down those witnesses if you're looking for your affidavit of execution, say 10 years later. So we do recommend doing that at the same time that you are witnessing a will. And now we're going to have some videos on wills and POAs.
Can I? I'm going to try this mic. Sean, are we picking this up? Yeah? Okay. Awesome. I just want to jump in on wills and powers of attorney because I think as a new notary especially, they are super intimidating. A client will come to your door or your office, wherever you are, and they come in with a will and they say, hey, I need to get this notarized. And I know we've seen it many, many times. That can mean a whole bunch of different things. First and foremost, it can be an unsigned, so a non-executed will or power of attorney, where the testator, the person who is signing their own will, is before you. And so they are hoping to have this thing signed. You're going to be one of the witnesses, and they're going to head on their way. There's other scenarios where it's someone who is bringing a will that was already signed, and it's someone who has passed away, and they need a certified true copy of that will. Unfortunately, in the average populace, in our population, not many people know what a certified true copy is. And so you'll have a client come to you and say, I actually need I need this will notarized, or I need a notarized copy of the will. And so there's a lot of, I'd say, confusion of terms by clients about what exactly they need done. So one of the sort of watch outs or red flags that I would mention particularly to anyone who is new to being a notary is to really ask the client, like, what do you need done here today? Or where is this document going to be submitted? Or where is the document going to be used? I think that's one of the most important things you can ask of anyone who's bringing a document to be notarized or commissioned. And Jaclyn's going to get into it with the affidavits of execution, but there's a second document that often accompanies a will or a power of attorney, which is the affidavit of execution, sometimes called the affidavit of witness. And what was that other one we saw? Self-appointed affidavit or something? Sometimes they're named something strange because they've been made up by a non-legal professional. And so, again, in your capacity as a licensed legal professional, you do have to apply a bit of your understanding of what the document is and what it can do before you just go ahead and witness it and commission or notarize it. And I think for myself, particularly when I was starting out as a notary, I was confused in several different situations when clients brought me a will, in particular one that was already signed. I found that to be the scenario where you would feel a little bit put on the spot. You're not really sure what you're supposed to do next because it's already been signed. And so these are some of the scenarios that particularly we find we have to train our newest notaries all the time on. And that's why I just wanted to jump in on this one. Thanks. On the videos.
How to witness a will. Wills are not legally required to be notarized. Rather, they only need to be witnessed by two separate individuals. Those witnesses should not be anyone mentioned in the will. They should not be a spouse. They should not be a family member, and they have to be over the age of 18. So both witnesses and the testator will initial the bottom right-hand corner of each page. And then once you get to the signature page, you're going to want to ensure that the date is correct. And then some wills will have this little line where you insert the number of preceding pages. In this scenario, there's 2 preceding pages. The testator will go ahead and sign their name. And then you as the paralegal would be acting as a witness. So you would go ahead and sign your name, fill out the information. Witness number 2 will sign their name, fill out the information, and that signature page is done. Now, we highly recommend that you do the affidavit of execution during the appointment. This will just save the client from having to track you down later. So here's an example. You, as the paralegal in this situation, would commission the document. So this affidavit should be drafted for witness number 2. So witness number 2, who is also the deponent, would go ahead and sign their name. You would then sign your name and use your commissioning name stamp. Then on the signature page of the will, you're going to want to flip that over, use your exhibit stamp, and use your commissioning name stamp. Of course, fill it out appropriately and sign. And then once all of that is done, you're going to want to staple it all together in one nice little package. Witnessing a power of attorney. So just like the will, powers of attorney do not legally require notarization. They just need to be witnessed by two individuals. Those people should not be named in the power of attorney. They should not be your family members. They should not be your spouse, and they must be over the age of 18. Both witnesses and the client would initial the bottom right-hand corner of the page. Client's name would go here. Whomever they are appointing would go here. Then the client would go ahead and sign, put in their address and their date. You as the paralegal would be acting as a witness here, so you would sign, fill out the forms, and then the secondary witness would go ahead and sign and fill out the fields.
Menti time. So the question this time around is, a client brings a document written entirely in a foreign language and asks you to notarize it and witness their signature. What do you do? And while you guys answer that question, I'd love to introduce Talia, our international document specialist.
Yeah, so I saw that a lot of people are choosing A, which is refuse service because you cannot read the document. In fact, you can. Okay, I'll see. How do I do that? Sorry. Okay, so as a notary, there are certain times that people will run into you, say, oh, I need this international document being notarized, but you cannot really read it. But that's okay, because there is no law or rule that forbids us to notarize an international document. Okay, but there are certain things the notary would need to do. So you must communicate with the signer in English and assure that they know what they're signing, they know the implications of their actions by signing this document. And also, the letters and characters in the document signature and in any ID document presented to you must also be understood by you, the notary. Otherwise, you will ask them to print their English name besides their signature so that you can read it, you can compare that with the ID document. And also, there is another way you can do. You can ask the signer to kind of like translate the document into English to you verbally so that you know the nature of the document. Even though that you cannot read it or you cannot write the language of the document, you can still notarize it. And the bottom line here is the notary must communicate with the signer and properly identify the signer, and also you will need to watch them sign. So they cannot bring a document pre-signed and ask you to notarize the document. At this time, you will need to refuse them. All right. And the next topic will be authentication and legalization. I'm not quite sure if you guys ever heard the terms, authentication and legalization of a document. Nope. Okay. So last year, I went back to China, and I brought my daughter there, and I have to prove to the Chinese government that she's my daughter. I know how silly this sounds, but I have to do that because it's a procedure. So I was wondering, like, how can I do that? Since she was born here in Canada, the only thing I have is her Canadian birth certificate. So I made a call to the Chinese consulate in Toronto, and they informed me that I have to get the document translated into Chinese, so the Chinese government would read it, and then I have to get the document notarized, authenticated, and legalized. All right, so authentication and legalization sometimes required before you can use a Canadian document abroad. And in some countries, authentication and legalization is also known as apostille. So authentication involves having Global Affairs Canada certify the seal and the signature on the document are actually from a notary public currently in good standing. And once you get that document notarized and authenticated, then you can move to the third step, legalization. So what is legalization? Legalization is done by the embassy or consulate of the destination country. A consular official confirms that the document is prepared appropriately and will affirm the certificate of authentication affixed by the Global Affairs Canada. So you can see that's actually as the certificate of authentication from the Global Affairs Canada. Yeah.
Awesome. Thanks, Talia. Actually, do you want to go back to the authentication slide?
That's the one. Nope.
I just wanted to chime
That's
in.
the
We
part.
lost the
Oh, the
PowerPoint.
connection.
There we go.
There you go.
So on authentications, just a quick practical tip. So I lived in Ottawa for 7 years. I actually just moved to the Toronto area just 2 years ago. So I personally attended at Global Affairs Canada to get documents authenticated countless times. As of right now, the last I've checked, this process is done by mail. You actually cannot go into Global Affairs to get a document authenticated. And the reason I mention that is you will occasionally get a client, kind of in your situation as you described, who will come to you and say, hey, I need to get this notarized because then I need to get it authenticated because I'm going to China on Saturday and I need to have the document when I get there. And it's like, whoa, hold on. So Global Affairs, unfortunately, is on, I think, a 6 to 8 week backlog right now. And you got to do by mail. So you have to build into your client's expectations that there is going to be probably a 2-month delay. Back in the day, pre-COVID, you could walk in to Global Affairs. The branch is called JLAC. And hand your document for free, and they'd put a big red stamp on it. You'd walk out of there, and you're on your way, and you can go to the embassy in Ottawa in particular to get the document legalized.
I think there is a fee, about like $16
there's
per
a fee.
document.
Yeah. And then the other thing to note, and I think it was just mentioned there, is get ready for all sorts of random requirements at each embassy. Some want cash, some need bank drafts, some need money orders, some don't take e-transfer. So there's a whole bunch of intricacies that you'll run into when you get into this world of international documentation. So yeah, you just want to, if you get into this space, particularly if you have clients doing immigration files or you're doing international trade where documents are going overseas, you're going to run into this authentication and legalization realm really quickly. It can be daunting, particularly, again, if you're a new paralegal, new lawyer, new notary, and you're wondering what all these terms mean. So, but it is a directly related field that is very closely linked to notary services. And the way we describe it to clients is there's a 3-step process. The first step is notarization. And so from there on, you may be in for a 6 or 8 week journey. So yeah, just wanted to add that.
Okay, thank you, Rob. Okay, so while we're talking about legalization, I put a sample of the certificate of legalization from Chinese consulate. Actually, is literally what is on my daughter's birth certificate. Right, so like Rob said, each embassy and consulate have its own rules and regulations. So there are certain exemptions on to this standard process. For example, I know that Indian embassy requires that the document has to have the gold or red seal. So it's not another type of seal. It's just the gold or red, the foil sticker you have to put on the document first, and then emboss your seal on top of it. So that's the procedure they go with. So you have to follow that. Otherwise, they're going to reject that. Right, and also like the payment, Rob said, some embassy require the bank draft, some are cash only. Those are the little things you have to check before you go there. The other thing I want to mention is, like as one of the largest online notarization company, we've done like tons of documents each day. But for a document that needs to be authenticated and notarized, legalized, you cannot get that document notarized online. Because when you do it online, it's an e-signature, e-seal, which is not accepted by the Global Affairs. And so the Global Affairs Canada requires wet ink signature and seal on the document. So wet ink means that you as one of the notary and also the signer will need to physically sign on the actual document. That would make the notarization like accepted by the Global Affairs Canada. Then you can move on to the authentication and legalization process. So that's about it, about the international document. So Danny, yeah, go ahead.
How's that? So it's a three-step process, right?
Yeah, exactly.
Authorization, then authentication, then legalization.
Yeah.
Okay, apologize. So it's a three-steps process as you described that.
Yeah.
So for you, for us as a notary public, we are only notarizing, right? So authentication and legalization. The notary provide that service for the courtesy, or it's a notary responsibility to provide the services?
Actually,
because in my humble opinion, when you stamp it, your notary job is done.
yeah, exactly. Like when people come to you, they will ask you, can you do the authentication and legalization? But for those part, actually, it's not fall into the notary public's responsibility. But I know that some, like if I'm a notary like public near the Global Affairs, then I probably would do it because people charge a little bit more for the whole process. And also like when you as a notary public, if you have like 4 or 5 authentication or legalization you have to go there once. Like prior to the pandemic, you can walk in. So why not, right? It's just like as a business tips.
Okay,
But
so it's just a courtesy, right?
yes, yeah, exactly. Right? Yeah, go ahead.
I think the authentication can be done by official documents, Ontario official document services, not only Global Affairs.
Yeah, so the question, because I think on the live stream, they won't be able to hear
Yeah.
your question. So you're asking, can the Ontario official document services also authenticate documents? So that's often called ODS.
Yep.
So the answer is yes.
Yes.
However, there's a little bit of a distinction there. A lot of times people will submit a document to ODS to authenticate the signature of the notary. And that can actually be a separate process from getting a document authenticated for use at an embassy for legalization and then for international.
Exactly.
So there's 2 different authentications that go on. And again, this is what I would sort of contextualize, I think a broader comment here, this whole presentation is nobody tells you any of this stuff. And when you try to interact with the provincial government or the federal government, like good luck getting someone to answer the phone to explain any of this to you. So, and I say that, you know, not to be snide or whatever, but it's complicated. And sometimes a client will come to you as a notary in your capacity only as a notary and expect you to fully understand the entire global regime of international document authentication and legalization. It's tough to even say all those words together. So, yes, to your comment though, ODS in Ontario, I think it's downtown Toronto, I want to say Jarvis.
Yeah,
They
222
will-
Jarvis.
Yeah, they will authenticate the notary's signature and actually compare it to the specimen they have on file, which, by the way, that's what you do when you are appointed as a notary. You submit a signature and a seal specimen to ODS. So, yeah, another question.
Yeah, this is about what Jaclyn was
Do
talking
you want to take the mic just so it gets on the audio for YouTube?
Hi, so this is a question about what Jaclyn was suggesting. So you showed some samples of documents that could have sufficed by them being commissioned and not necessarily notarized, although this is a notary presentation.
Yep.
The documents that need to be just commissioned, for the purpose of commissioning, what necessity do you find to stamp it as opposed to writing it, your commissioner and your P1 license, and get it over with? Why go make it more fanciful, get it embossed stamp on it, and then have the additional stamp on it, if the documents that is only commissionable to be turned into now a notary, per se?
That's a great question. I'll hand it to Jaclyn. I have some thoughts, but go for it.
Honestly, I would just say because the average consumer doesn't understand what the difference is. So by sealing it, by providing that ultimate level of commissioning, if you will, you're making the client happy. Because they don't understand what the difference is between a commissioner and the seal and the stamp. So, I mean, it doesn't cost you anything. You already have your seal, so just throw that seal on there. The client feels like they're getting what they want, getting what they need, because they don't understand that they don't actually need it.
So I just have a follow-up on that.
Yeah.
Thank you.
We only have the one floating mic, right?
So you the mic there.
So my follow-up
Well, there is
question,
Okay.
so how about commissioning or making it fancier, notarizing a commissionable document in interjurisdictional? Someone is in Vancouver, they reside there, they have a document that needs to be commissioned or notarized, they happen to be visiting Ontario, they come to your office for a document that is to be done by a notary in the province of British Columbia. Do you cross it out, do it in Ontario because they're here, for the usage there?
Yeah. Yeah, so, and by the way, I'm gonna make sure I'm in the camera here, I don't know on YouTube, but sure. So just to jump back to your first question really quick and to sort of echo what Jaclyn's saying, I've in the past only commissioned a document and then had a client say, can you put the seal on it? So I think there's a general knowledge or perception in, let's say, the average consumer's mind that when you go to a notary, you should get a seal on the document. But like, when you look at the Commissioner for Taking Affidavits Act and the Notaries Act, you are not required to seal when you're only commissioning. Interjurisdictional question, so if a client brings an out-of-province document to you, yeah, you would scratch out the wrong province, you would write in Ontario, and then you would use your Ontario notary seal to indicate that it was notarized in Ontario. I've had clients over the years, I mean, I've personally notarized probably tens of thousands of documents, and I've had clients question scratching out information and correcting and making changes to the jurat, that's the signature box. Again, in my experience, I've never had an issue with scratching out and correcting a jurat. Where I have had the occasional issue is when I've missed scratching something out. So if you leave, let's say a reference to the state of Florida, and you're not in the state of Florida, you'll get some particular individual, I'll just say, take issue with the fact that you forgot to change the jurisdiction of the document. Again, that's them doing their job, but it's sort of an obvious, correction. I'm getting a flag here. Are we losing audio or?
No, we got a question online.
Oh, a question online. Awesome.
After authentication, some countries may not have an embassy in Canada. What can they do in such circumstances?
So after authentication, some countries may not have an embassy in Canada. So what do they do next? Yeah, that's a great question. So Ottawa, of course, has the predominant number of, let's say, official embassies. Sometimes in Ottawa, you will only have a consulate. I can't think of an exact country, but there are some embassies that are in Montreal or Toronto, and then there's consulates in opposite cities. But generally, all the embassies are in Ottawa. Often, you would need to send the document to an embassy in another country. Typically, the United States. We have the advantage of having the United States across the border. So if you do have to send a document, you could send it, after being authenticated at Global Affairs, you could send it to their embassy in the US. I think there's a lot of, I'm looking at the team here, I think you're off camera, but I think there's a decent number of countries that only have embassies in the US, and they may have a small consulate in Canada. That's a great question, and thank you for whoever asked it. Did I answer your question though, the jurisdictional?
Yes.
Yeah, okay, awesome. Any other questions here before we move on? Want to take a quick break? Okay, like what are you thinking? 2-minute break? Sorry, YouTube. 2-minute breather? Good? Okay. 5? Okay, we're gonna come back in 5 minutes. Quick breather, and then we're gonna jump on to the shift to online notarization. If anyone in the audience has any questions now, though, I'm happy to discuss or chat. Thank you.
usually I'll be here. Notary public.
I rented offices from criminal lawyers at Korean Bay on the state.
Can I have from where I have to download this law? Do you have any information that, like, any number who can guide us, please?
Everyone back from coffee? Perfect. Okay. So, yeah, welcome back to our guests here in person. And if you're online, hopefully you got a coffee or something as well. So again, I'm Robert Onley. I'm the founder of Notary Pro. I wanted to, before we jump to our topic on online notarization, I wanted to address a couple of questions that were asked here in person during the break. And what I've put on screen here is from our video that was shown earlier about the witnessing of a will. And so the question that was asked is it necessary to mark the back of the will with an exhibit stamp? And before I kind of answer that question, I'm going to explain that when we are onboarding new notaries into the Notary Pro network, we are now requiring notaries to get the exhibit stamp. And so it's kind of a hint of my answer, which is yes, you do have to mark the back of the signature page of the will as an exhibit. I'm not sure if we've lost the feed on the YouTube, but it's not on the screen there. That's okay. So the question is, do you have to, or can you mark the signature page of a will somewhere else as Exhibit A to the affidavit of execution? So again, for context, and especially for new notaries, the affidavit of execution is the document signed by one of the witnesses who also signed the will, which you, as a notary commissioner, paralegal, superhuman, also then commission. And so as part of the commissioning of the affidavit of execution, you are then going to take your big, beautiful exhibit stamp and mark the back of the signature page of the will. And so the question that I was asked is, do you have to do it on the back of the will? Could you just do it on the front, or could you do it below the signature block of the signature page of the will? The quick answer, and I'm not an expert estates lawyer, so that's my disclaimer for everyone on YouTube for all eternity, is that there is, in Ontario, there's the Estates Practice Manual, or the Estates Manual. I forget the exact title, the most recent one, but the manual refers to marking the back of the will as the exhibit. And so the reason, as I was explaining here, is by marking the back side of the signature page, you, in your capacity as a commissioner, are effectively evidencing that you handled the execution page on the date that it was executed. So you are providing a further assurance that not only was it signed before you on that day, but also that the witness who is swearing the affidavit of execution also signed the affidavit of execution on that same day. So it's a further proof of the will, which for probate purposes will further support the authenticity and the veracity of the signature of the testator. Again, I'm not an estates law expert. There's lots of great firms and platforms that are focused on that area. But again, in your capacity as a notary, nobody really tells you this stuff. And in my capacity as a lawyer, when I was starting out, no one explained any of this. I really just had to learn it on the fly. And so that's, again, part of what Notary Pro is trying to do. So this is a really important one. And to be honest with you, this exact process, this step of marking the back of a will, and I'm looking at my team here, is probably where new notaries trip up the most, and they panic and they call our amazing notary manager, Jaclyn, saying, what do I do? The client's here. I think I'm supposed to do something on the back of the will, and they forget this step of the process. So if there's a takeaway here, it's just, yes, get the exhibit stamp. Make sure you mark the back page of the will when you're doing the affidavit execution. And we have a question in the audience, so I'm going to hand you, or maybe, yeah, we can do the second mic. Yeah, perfect.
Thank you. One quick question. So do we have to stamp exhibit stamp to put on every page of the will? Because some wills contains 2 pages, some will may contain 10, 15, 20 pages. Do we have to put exhibit and mark them alphabetically on the back of every page of the will, excluding affidavit of execution? Am I right?
So to answer your question, no, you do not have to mark every single page of the will as an exhibit. So I'll put a little more context on this, and I hope it's edifying for everyone, which is when the witness is signing the affidavit of execution, they are swearing or declaring under oath that they saw the testator sign their will on a certain date and time. And in that affidavit, they are also saying that I saw the signature on the document that is attached as Exhibit A. And so typically it's just Exhibit A. and you would only need to mark the back of the will as Exhibit A. So you don't have to mark every page of the will as a separate exhibit. What you're saying is that will, which you've now marked only on the back, is Exhibit A to the affidavit of the witness to that will, or sometimes that power of attorney, which it can be called an affidavit of execution or an affidavit of a witness in the context of a power of attorney.
Okay, if there's multiple pages fields, what page you recommend to stamp by exhibits then? First or last?
I would always mark the back of the signature page of the will or the power of attorney. Yeah. Yeah, and that's where, so, and again, I can speak just from some experience and then I'll keep us moving, is if you mark the wrong page of the will, or if you don't mark it, and then that client has to take or submit the will or the power of attorney to court for probate purposes, it is likely to be rejected by a clerk who's going to say where's the affidavit of execution, or there's no evidence that this will is actually part of this affidavit of execution. So you'll create a bit of a break in the chain for that client when they go to have the will proved by the court for probate purposes.
Thank you.
Yeah, thank you. That's a great question. And so, unless there's any other questions from the audience, I'm going to shift to our third and final sort of segment, which is the shift to online notarization. And I'm going to introduce our amazing paralegal notary, Danny Hua. Welcome.
Awesome. Thanks, Rob.
Thank you, Danny.
Appreciate that. Hello, everyone. Great to see all your faces, fellow colleagues, and sorry, maybe I'm get to the right slide.
Oh, you're going to have to click forward if you...
All right, so talking about online notarizations. Now we're talking about when I refer to Ron, not referring to Ron Burgundy from Anchorman, but we're talking about remote online notarizations, breaking up the presentation into really 3 sections. But first thing we'll talk about is, on a high level, the law that allows for documents to be electronically signed. We'll run into a couple of examples of how to tag a document so that it can be signed online, and then some pitfalls to watch out, things that could be time consuming. But so it's Ontario Regulation 431-20. So still relatively new. This just came into place kind of at the beginning of the pandemic. Really lots to say about how that has impacted, the field of virtual commissioning. To kind of give some context, when I first started with Notary Pro as to be on the Ron team, it was a high volume of appointments where every hour we're meeting 4 or 5 different clients, and I just jumped into the role. It was a kind of just standard. But I'm very curious, and Rob, I'm wondering if you can come in and provide some context on what did notarizations look like prior to this regulation. If I lived in, for example, like a remote place and I needed a document notarized and I couldn't do it online, what did the situation look like, and how did this impact the business?
Yeah. Thanks, Danny. I guess I could just use this mic.
Yeah.
So yeah, and just to sort of chime in here with a bit of context, because for most paralegals particularly, the fact that the Ministry of the Attorney General in August 2020 enabled paralegals to be appointed as notaries, that also fundamentally shifted and coincided with the Ministry of the Attorney General implementing Ontario Regulation 431-20, which authorized the use of electronic signatures and audio-visual communications for the purposes of signing documents. Before this regulation in Canada, you could not meet with a notary public or a commissioner of oaths online. And I think one of the key distinguishing elements I would mention right off the top is this regulation specifically permits virtual commissioning. It is not actually explicitly referring to digital notarizations. And one of the things as a company we've had to do very carefully is explain to clients that what we call online notary services in fact and in effect virtual commissioning. The reason we use online notary is because that's what clients call it and that's what they think it is. There are some distinguishing features that we'll get into in the presentation, but there are certain things that you cannot digitally sign or virtually commission online through our app or any other of the online notary apps. When this regulation was launched by the Ontario government, so it was in March of 2020, which coincided with the pandemic, in effect, the Ontario government was actually catching up with a large number of US states that had legalized remote online notary services 6, 7, 8 years prior to that date. So in many respects, this regulation 43120 was a belated catch-up to where the United States has been for a long time. And in fact, in the US today, so late 2022, the Congress passed the Secure Notarization Act earlier this year, and it's expected to pass through the Senate at some point next year. The Secure Notarization Act in the US, what that is going to do is ensure that all digital notary acts are acknowledged and respected across any state from any notary from any other state. So ensuring interchangeability and interjurisdiction respect and acknowledgement of digital notary acts. So without taking too much of the rest of the presentation here, that's a little bit of the history that in many respects enabled Notary Pro to really launch and come to the fore as an online notary platform. Lots more that you can learn about that on our website, but all that to say, this legislation is what has fundamentally enabled the shift to online notarization in Ontario and in the rest of Canada. Thanks, Danny.
And really cool thing about this legislation is it's pretty straightforward. Like what we see here on this page is essentially the 6 elements that we need to cover before a document can be electronically notarized. So the first is that the person administering the oath or declaration and the deponent or declarant are able to see, hear, and communicate with each other in real time throughout the entire transaction. So you'll notice throughout the legislation, there are a couple of words that are used interchangeably. So an oath is synonymous with a declaration, a deponent and a declarant be one and the same, and a commissioner, to bring some clarity, because we had a question during intermission, we know what's the difference between a commissioner and a notary public. Well, commissioner is someone that is authorized to commission affidavits and declarations. So that's court justices, clerks, but not all commissioners are notary publics. And all notary publics have the same power as a commissioner, so just provide some clarity there. To just touch lightly here on this first point as well, if we are not able to see and communicate with the client in real time, then that poses an issue. So we'll talk about a solution on how we can resolve some of those video issues that come up regularly. But we need to see them so that we can confirm their identity. At Notary Pro, we actually have the client upload a piece of ID. And when we meet with them, we ask for them to show it up to the camera so we can confirm their identity. We prepare the document so that it includes a modified jurat text, so that it indicates that the commissioning was completed in accordance with this regulation, and for it to indicate the locations of the parties that are signing the document. 1.4, every commissioner whose appointment is limited in its duration shall indicate the limitation. So the nice thing about being a notary public is that the commission does not expire. The person administering the oath or the declaration takes reasonable precautions in the execution of their duties, ensuring that the deponent or the client declares what is being said. There's a lot that we can go into there because there's such a wide spectrum of documents that need to be signed, and for the most part, people that need a document notarized, they don't really know what notarization involves until they're requested to. So there's a lot of responsibility as a notary to just make sure that the client understands what's being signed, and typically a simple question just like, so what's the document that we're signing? Will usually give some room for the client to provide some context. And this last point, every person who administers the oath or declaration in accordance with Section 1 shall keep a record. Rob.
I wanted to jump in here on one the previous slide here. So there's a key point in the process when you're providing a virtual commissioning service, which is section 1.2. So it's the confirmation of the identity. Some of you may know the Law Society of Ontario recently issued an update with respect to their client ID verification requirements. These requirements come into effect in January of 2023, so just under 2 months away. I'm not sure if this PowerPoint is dropping in and out for everyone on YouTube, but we don't really need it for this segment. But all that to say, the client ID verification requirements are changing fundamentally for licensees in particular in the new year. And what that means is there's going to be a requirement to use a form of technological ID verification, typically referred to as knowledge-based authentication or ID verification, IDV. There's another acronym you might start hearing, KYC, Know Your Client. There's different platforms that use different ways of confirming someone's identity beyond simply checking their ID card. One of the interesting things as it relates to virtual commissioning is, and the notary services generally, is these are not legal services which are captured under this ID verification requirement. So what that means is, as of January, and we've spoken with the Law Society directly, I'm just getting an Amber Alert. Oh, hope the best there. In the context of notary services, these new ID verification requirements are not relevant, or they do not apply to notary and commissioner services. However, as ID verification platforms mature and as they become more readily available for legal professionals, including lawyers and paralegals, Notary Pro in particular as a company, we will be implementing ID verification systems and tools into our processes. It isn't required though yet. It won't be required for notarizing and commissioning documents in January. But I'm mentioning that as the profession shifts and as these technologies mature and become more readily accessible, we fully expect that to be part of the mandatory step when you complete an online notary service.
Other question?
Yeah. We have one question here, and then we're going to let Danny keep going, but yeah.
Danny, regarding the first part,
Yeah.
to see the client in real time and the entire transaction happening in real time.
Yeah.
So we practice in POA courts. So let's say I have a provincial offenses matters, right?
Mhm.
So we have a client in Windsor, they got a ticket in Toronto, they got convicted, we are doing the reopening. We have to send them the affidavit in support of the reopening. We have verified their IDs, we know it is our client, we have checked that part.
Mhm.
So when we send the affidavit in support of the reopening to them electronically to be signed, how do you propose for us and them in two different locations to have these electronic documents to be signed live after us being satisfied that this is a client? Because if the entire transaction is supposed to happen live in real time, by them signing and us signing, are you referring to as docu-signing it live or paper signing it, and who signs which copy in order to exchange to send to court?
Well, there's lots of platforms that you can use to create the signatures. DocuSign is one. Adobe has its own. We use a software called Sign Now. But you want to be able to be in, you want to be able to communicate with them in real time. So there's various apps that you can use. You can use Google Meet. That's a popular one to meet with them. Zoom,
Right.
Teams.
I understand the meeting live, so you're suggesting that I'll have my version of DocuSign open, they'll have their version of the DocuSign open, we are meeting on Google Meet, on a separate screen, we each have a DocuSign open, and then sign it live electronically? Does that suffice?
That would. Rob?
Yeah.
But maybe I'm missing something.
Yeah, so this is the million-dollar question right now, and without giving too strong of a, let's say, sales pitch for Notary Pro's platform, this is what we've combined, is we've combined the video call, the e-signing, the client ID verification, and the signing, and the appointments functions all together at once. What you then create is a digital timestamp and an audit log of basically saying this individual appeared at this time, e-signed at this exact moment at the same time as the notary was signed in, and saw them witness and sign their document, digitally sign their document. So you're creating a record log of all those activities occurring at the same time, which creates a hopefully verifiable proof that that individual signed at that exact moment. The downside or the challenge of using these sort of disconnected technologies is you don't really have any way of actually saying, at this time, this individual was on a video call with me when they e-signed this document. So, and there's quite a bit of little, nuances there. I'm happy to kind of dig into them, but in the interest of the time for tonight, we're going to let Danny keep rolling, but honestly, happy to chat after.
The great thing about working for Rob is regardless of what topic it is, he's so articulate and fluent and answering any questions, like he's always prepared. So I try not to let you down here. But the Electronic Commerce Act, this Section 31(1) are the documents that cannot be electronically signed. So very frequently, we see wills, codicils being uploaded to be electronically signed, and unfortunately, we have to cancel these appointments. Trusts created by wills and codicils, so really anything that has to do with the estate's administration, probate, these documents we can electronically sign. Powers of attorneys, very common as well, especially when it's regard to an individual's personal affairs or personal care. Section 4 has been repealed. 5, so negotiable instruments can't be electronically signed. These are promissory notes, essentially any document that deals with the repayment of debt, and documents that are prescribed or belong to a prescribed class. Believe this is legislators' way of just creating space for them to make changes in the future if they were to decide that certain types of documents can't be electronically signed. All right, so this is an example of how we tag a document in our RON platform. First step, adding the signers. So in this example, signer 1 and 2. The second step, we add these signature fields so that both the applicant and the notary can sign. The next step, gonna add, oh, one sec, we'll just wait for, just gonna wait for the screen to load. So this is the stamp field so that we can electronic stamp it. These are the text fields to indicate the location and the date of the appointment. At the bottom, I put our contact information. That's supplementary so that the recipient can reach out if they should have any questions regarding the electronically signed document, or if they just want to confirm and verify with us that it's authentic, that we were there. The name and title and LSO number for the notary. And then lastly, to comply with the regulation, this modified jurat text that indicates it was completed in accordance with the regulation and the locations of the parties signing. So that's how to tag a document. And the last section here, talking about things to watch out for. Certainly, with technology, there are an infinite amount of things that could go wrong. And from my experience, the longer a meeting drags out for, the more the stress compounds. So hopefully, I can provide a ton of value over these next few slides as to how we resolve a lot of problems. So probably the most common issue is a video not loading. So we're trying to confirm the identity of a signer. And so when the client joins the meeting, they'll typically see this pop up, and I guess, naturally because of marketers ruining everything, pop-ups, we just want to block everything. But this is actually a request for the browser to access the client's camera and their microphone. So they need to allow. Most times people block it. So this is an example where I'm blocking the camera, what clients typically do. And this is what happens. We see this notification that the client has joined the meeting, but there's no video. And so the challenge becomes, we got to communicate some information to the client. This sometimes can be very difficult to articulate, but all they need to do is click on this little icon, this lock icon here, and then they just got to select allow there so that the settings, the browser settings will allow our site to access their camera. Of course, there's more than one way to get to it. There's also this video icon to get to the settings, but once that's allowed, this is Google Chrome, but a refresh right after that setting is adjusted, and the video would work. Created this video today. Yeah. So what if the document is signed in advance? Also a very common situation where clients upload the document to us with a signature already there. We can't notarize this because we can't certify that we've actually met with the client and that this is their signature. So what we need to do prior to the appointment is to remove this. So appreciate Adobe for their services, but the edit button here at the top of Adobe would allow us to, I apologize, let me bring this back. So there's this edit button here at the top of Adobe. The system would then recognize that there's text on this document, and we very simply remove the signature. Now, oftentimes a signature may not be recognized, especially if it's a physical one. So assuming that Adobe doesn't recognize the signature, there's another way to remove it, and that's just by exporting the document into Paint. Of course, various other solutions to this, but this is just the way that I find that involves not too many steps. But essentially, we just crop out the signature, and seems pretty simple. It's just a few steps, so not much to it. But yeah, when we go into the meeting, we want to make sure that there's no signature. Rob, some context, please.
Yeah.
Some rambling.
So no, this is great, and I think what it also raises the question in my mind anyway, which is if it's that easy to remove a signature, like can you not just fraudulently add a signature? And so when you are using a platform such as Notary Pros or any of the other major electronic signature services, typically you will have, when you insert a signature, the document itself becomes locked and the signature becomes bound to the PDF file. When you open it in Adobe, and I don't think it was shown on this screenshot here, or the previous one, but there is the Adobe Trust List certificate, which will display when you've properly electronically signed a document. And so this step is more so targeted at someone who's obviously pre-signed a document, which, by the way, in person is one of the most common issues that you'll confront. A client will come to you with a document that's already signed, and you have to either ask them to print another copy, bring another copy, remove the signature. There's a lot of hassle that goes with it. But when you are doing a online notarization or a virtual commissioning, you obviously don't, you cannot re-sign a document that's already been locked for signature by a previous digital signature. So there's a lot of little nuances that will come up along the way when you get into providing online notary services. So I don't want to take up too much more time though, Danny, so I just wanted to mention that.
Thanks, Rob. Well, now that we know how to remove signatures, we're going to move on to a very common example. So question is, what if you know the client is signing the wrong document? This goes back to section 1.5. As a notary, one of our duties is to ensure that we're taking reasonable precautions to just ensure that the client understands what they're signing. So this document on the left is, these are both transfer documents for a used vehicle. They look pretty much identical, but you'll notice there is a difference, and this is regarding section 4 and 5. So this is when a family member is trying to transfer the vehicle to another family member. But if they provide or they fill out the 1155E, oftentimes it'll be rejected because they're family members. They need to be filling out the correct form. But it's a minor nuance, but it is important that we will confirm that the client is completing the correct document. And last slide here, a general a tip to resolve most problems is just being proactive. Might seem familiar. It's from Stephen Covey's First Habit to Highly Effective People. It's based on this concept of, we are a product of our decisions and not our circumstances. So every decision we make, it really determines, the result at the end. And I guess how that applies to notarizations is, while we may differ in various different ways, one thing that we all have in common is we're just trying to move our lives forward. We're trying to, elevate our lives, and so are the clients. And the worst thing that could happen is not asking the right question or just assuming that they understand what they're signing and the document gets rejected. And they come back, and then something that was supposed to take, a short period of time, it suddenly is prolonging the process. It's nice that we are all, have this in common. We're all notaries and just trying to help our clients move forward. And now you're going to get quizzed. So last mentee here. This one is a pretty tough one. It's a trick question. So sorry.
Okay.
Huh?
okay.
You got it.
I do.
Oh, right.
That's all good. Don't worry.
Oh. Where's the question?
Might want to give them a chance to scan through.
Let's read the questionnaire, because it's
Uh,
yeah.
Question will be on behalf of
oh. Apologies for the delay.
Yeah,
Yeah.
I'll read it, okay.
So Grace, this is the question, this is meant to be the sort of final skill testing question here. Grace asks if it's possible for her to sign on her mother's behalf. Can she? You're meeting with a client, Grace, and her elderly mother, Susan, who are in two separate locations. Susan tells you that she was born in the 1930s and is not tech savvy. She gets increasingly frustrated because she's not able to sign the document. So the question is, can Grace sign on her mother's behalf? And again, this is in the context of an online notarization service. And to be honest with you, this type of thing happens to us all the time. We're doing thousands of these appointments a month, and people try all sorts of things. So the answers so far look pretty unanimous.
Guess it's not a trick question.
Yeah. Do you want to go into it, or?
Sounds like everyone understands.
So yeah, the audit log. So if the daughter were to sign on behalf of her mother, the audit log and the video call would evidence very clearly that it was the daughter who e-signed on behalf of her own mother. So not only is it improper for someone to sign on someone else's behalf, unless we're talking about signing a will and not being physically able to do so, which, by the way, you cannot electronically sign on an online notary platform yet, hint, hint. It's obviously not something that would be permitted or encouraged, and there would be serious concerns of fraud in that case.
Rob, stay here
Yeah.
because
Or
you're next.
I'm next. Okay.
Or you're
Thank you, Danny. So I wanted to wrap up here. Obviously, we're close to time. If you're still with us online, thank you. And for everyone here in the audience, thank you as well. I just wanted to, before we jump into question and answer or anything that you might want to raise or ask, I just wanted to give a shout out to the paralegals that are watching that are here physically and online. Notary Pro is, as I mentioned at the outset, we are now a majority paralegal organization, and I just really want to commend everyone who has applied to join Notary Pro in the last while or in the last year and a half or so. We can't do what we do without you. But I also just wanted to simply give a plug quickly to say, if you are watching and you're interested, or if you're here and you're interested, please reach out to join our notary network. So you can do that at notarypro.ca/apply, or simply send us an email, apply@notarypro.ca. There's a couple quick notes here. It's a great way to grow your practice if you're just starting out. You can pay off your student loans. The beauty of working with Notary Pro is we handle all the client scheduling, marketing, and administration for you. There's no startup fee, there's no license fee, and as I say, there is no monkey business in the contract when you join us. It's very simple, and we'd be happy to have you and grow alongside you. I say all that and then would love to jump back, and I should also say on the side here, this is our amazing team at our retreat in Oshawa, not far from here, just 2 weeks ago. And so we're really excited to hear from any of you if you're interested. I'm going to go back to our Q&A slide, which is not here. But if anyone has any questions and answers, or sorry, questions for us, hopefully we have answers. If you're online, I guess it's in the YouTube chat. I don't have access to see that, but if there are any questions, yes, sir, in the back. And we can try to get a mic to you, so the audio will be on the YouTube clip.
Thank you. So my question is the following. Let's say we're doing an online notarization and the client is, the document isn't for this province, right? And we're just commissioning an oath. Would that work for a client? Although we're in Ontario, let's say they have a document in BC, which from BC, which I've done some real estate, closings and documents, things like that, where their person is physically in Ontario. They bring the document, you just cross out, and you're just writing Ontario for the jurisdiction. Are you doing similar things for the online notarizations, or the document has to be just within Ontario jurisdiction and clearly states so?
Yeah. So for, just to make sure the audio is, you're asking, can you provide online notary services or virtual commissioning even if the document is destined for somewhere outside of Ontario? Is that a fair kind of recap? Yeah. So this is a great sort of jurisdictional legal question that we've run into multiple times over the last 2.5 years, that virtual commissioning has been regulated in Ontario. So in various consultations with the Ministry, the Attorney General, and other entities that we've encountered or let's say bumped heads with, we've concluded and determined that yes, you can provide virtual commissioning services if the document is destined for a jurisdiction outside of Ontario. The reality is, with the state of affairs and particularly the pandemic, for a lot of people, they had simply no other choice. And the great example that we have is a federal government form that was, the short code was IMM0006E. That's the English, there's the F if it was French. This form allowed people to invite their family members to come into Canada to cross the border even during the national and provincial lockdowns. That was a form where we had clients who were typically in Canada inviting family members who were overseas who also had to sign that form and then get it commissioned by a notary or by a lawyer paralegal. That form was one that we, the federal government launched and announced out of the blue with no notice to companies like Notary Pro and said, you have to get this notarized. And so out of nowhere, as a company, we had hundreds of people booking with this form, all in the same random week in October 2 years ago. And the reality there was, just to kind of answer your question, we had people all over the place, all different provinces, locked in their houses, like literally by law, locked in their homes, if you will, not physically, but in terms of the lockdowns. And so they had no other choice. They had to get it digitally notarized. We were fortunate in being a company that provided that service at the outset of the pandemic. And the reality was we had no issues with acceptance. The documents have been and continue to be universally accepted. That's favorable to us as an organization because we've had lots of people from all across Canada use our platform, in effect, use the regulations that govern here in Ontario to enable them to accomplish business and move their lives forward in BC or Alberta or other provinces. The caveat to my answer is occasionally a recipient of a digitally notarized or virtually commissioned document will take issue with the fact that it was done in Ontario, in which case, typically, we very nicely say to the recipient, give us a legislative reason that you have to reject this virtually commissioned document, which was done validly and legally here in Ontario. And often that works. They simply say, yeah, you're right. We don't actually have a reason to reject it other than they are not used to it or they haven't seen it before. And another example of this, just to kind of build on this theme, because to be honest with you, it's probably the biggest bane of our existence as a company. We've had a ongoing, I'll say, dialogue with the wonderful people at Service Ontario here in Ontario to ensure that virtually commissioned provincial documents are accepted by clerks at the 330 plus Service Ontario locations across the province. That's an example of, I would say, regulations getting ahead of common practice and industry understanding within a regulated environment like one that Service Ontario operates in. So we had sort of first mover advantage as a company. We started doing virtual commissionings before the rest of the economy even knew it was a thing. because I don't think most people, if you've run into them on the street, know what Ontario Regulation 431/20 is. So yeah, it's a mouthful. But again, to answer your question, there is one additional point, which is cross-border documentation. So we regularly run into situations, or clients, I should say, with snowbirds. So Canadians down in Florida, they get some timeshare scenario, they panic, they want out, they have to get these quit claim deeds signed, and they think, hey, I'll use this Canadian notary service. So they use us, send the document digitally, if you will, back to whoever they need to in Florida, and the Florida whatever agency looks at it and says, we don't know who these Canadian notaries are. And so that's just a challenge for us as an organization, and we're doing more proactive outreach at the more of the business level to advise other jurisdictions that, yes, we exist as a Canadian digital notary platform, but there is no, again, there's no regulation that we're aware of in Florida, as an example, that would justify rejecting a Canadian notary, paralegal, virtually commissioning a document for use in Florida or around the world. And in my view, just to finish the thought, this is all inevitable. The virtual commissioning, digital notary, ID verification, it's all coming together technologically, and it's just going to be a matter of educating the market, educating the average consumer that this is happening and this is valid, this is legal. But it's up to us as legal professionals really to educate your client on that one-to-one basis when you're on a video call with them, to explain to them what they need to do in the event that the recipient of their document rejects the document. Hope that answers your question. We got another question in the front here.
Thank you. My question related to multilingual notaries. As much as I know, the notary public cannot notarize self documents for himself. In case of paralegal lawyer, notary public, that multilingual and other than French, other than Canadian official languages, is it possible for notary public to make self-declaration for translation? That notary public fluent in this language, in English language, and French language, and translating document from whatever language to one of the official Canadian languages.
So I hope that the audio was all picked up there. The TLDR, which is the new acronym we're using a lot, too long didn't read. The question is, can a notary notarize their own translations? Yeah. My quick answer would be, I don't know what the regulations say specific in this regard. I don't think there's anything that prohibits it. I would say as a best practice, and having done notarizations for about a decade now, I wouldn't recommend it. I think you're setting yourself up for a rejection. I think that the reality is a recipient is going to look at that and think something's kind of off. That said, I don't know of any regulation that would prohibit it. But it is one of those situations where, and I would say, frankly, as a general comment, under the Ontario Notaries Act and the Commissioners for Taking Affidavits Act, there is a lot of, I'll say, blank space. I wouldn't say gray space, but there's blank space where there just are no regulations. There's nothing said about a lot of the conventions and best practices that as notaries and as legal professionals, we employ in our capacity as commissioners and notaries. It's really, I think, as Jaclyn said off the top, it's a historic profession that we've collectively kind of passed down through the generations. And now that we're running head on into technology, I think the profession is owed a bit more comprehensive overview and some guides to help us navigate all these situations. So I wouldn't recommend it. I'm personally not able to translate into multiple languages. So, but if you've done that in the past and you've been successful, then I don't know of any reason not to be able to do that. You might want to look at, and I guess we have a question online, but we might want to look at what the Commissioners for Taking Affidavits Act says in terms of the declarant and the deponent. I could foresee someone arguing that that act only refers to two separate people when you're completing an act of commissioning. So that would be my theoretical answer, yeah. We have an online question?
On the Notary Pro website, there was a question about meeting with clients at home/office. Could one meet with clients at a library or book a schoolroom at a university as an option?
Yeah, so can you as a notary meet with a client in a location other than your office or your home, I would say absolutely. Yeah, and it's quite common, to be honest, particularly in the United States, to provide mobile notary services. You'll meet a client anywhere other than your office. I think in the Canadian market for notary services, it's much more common to actually meet at an office. I think there is a perception that because you're a legal professional, you should be meeting in a professional setting. That said, Notary Pro, to be honest, started with me notarizing documents in my townhome in Nepean, in a very random suburb of West Ottawa. And I met lots of clients in my living room, and that's really sort of the grassroots start of what is now Notary Pro. But there is no regulation or prohibition that specifies where you physically meet. Okay? Go for it.
I would just like to say that Notary Pro does not allow our notaries to meet with clients at like Tim Hortons because we cannot market you as a Notary Pro location from a Tim Hortons. So, sorry about that.
Yeah, and I think we have a follow-up question here in the audience. Maybe, Angie, do you have the mic? Oh, here's the mic. Or Jaclyn has it, okay.
Yes, but in the jurat section, you said that it's signed perhaps in Richmond Hill. But if you're actually doing it at library in Toronto or Mississauga, how would you put that location in? What would you write in the location?
So are you referring to, so the question is if you're in a different location than the client?
Yeah.
If it's an online signing, you mean?
Yes.
Virtual commissioning?
Or either or. I mean, it's an online or an in-person event.
Yeah, so in the context of a virtual commissioning, I'll try to answer your question and clarify it a little bit, is if you are in a different location than the deponent at the time of the virtual commissioning, the jurat must state that so it's typically you say sworn before me in the city of Richmond Hill while the deponent was located in Toronto, Ontario or Windsor, Ontario. So as part of, for example, the way Notary Pro provides virtual commissioning services, we specify the location of the notary and the client every single time. That's baked into our protocol, and that's actually in compliance with OREG 43120. So you would just need to make sure you're always specifying that. Typically, and I know we're in Toronto right now, and I think the majority of people here are from Toronto, so you can say, in the city of Toronto in the province of Ontario, even if you're in maybe Scarborough or Richmond Hill or what have you. I think you can use Toronto as a catch-all, given the size of the city. But typically, I specify the exact town that I'm located in.
What if you're out of province notarizing something to say Ontario? Is that possible?
So the question is, what if you are out of province and you're notarizing something for use in Ontario?
So can you notarize a document in person for a different province if the client is in Ontario at the time of notarizing?
Yes, so and I'll try to repeat the question. So can you notarize a document for a different province if the client is in, was it Ontario at the time? Yeah, so again, I always want to be clear here if we're talking about an in-person service or an online service. So I think I just answered the online scenario. If you're in a different city, you just specify. In person, yes, absolutely. As a Ontario notary and commissioner, you can notarize and commission a document that is going to be used in another province. And I would say this is another point that we fundamentally have to explain to new notaries and paralegals in particular, and lawyers, but new notaries, I mean. Basically, the fundamental role of the notary is to witness the ID and the signature at the time that the document is executed, so that the authenticity of that signature at any other point in the future is confirmed and assured by any recipient. So that means you can be in Ontario and notarize and commission a document that gets used in BC in a month, and the recipient in BC a month later has no concerns by virtue of your signature and your seal. I think it was asked earlier, do you need to put the seal? I'm of the opinion, and it's always been my practice, to put the seal on everything. The notary seal, I'm talking the embossed seal. The reason being, you don't know where and when that document is going to end up on someone's desk. Why give them a reason to doubt the authenticity? The embossing stamp on a physical piece of paper, even in 2022, basically says that notary signed it on that date and that time in front of that same deponent or declarant. So I would really strongly recommend it. Another question here, yeah.
So, notary public, you're a notary public in the province of Ontario. In the beginning of the presentation, you said you'd notarize and commission documents for family members. You're visiting Uncle Joe in British Columbia. Hey, Sam, I got something to be notarized. You are a notary public in Ontario. can you notarize a document for the purpose of usage in BC while you're there if you have your embossed stamp?
So I hope the audio is picked up. But basically, if you're an Ontario notary physically located in another province at a given random point in time and you are asked to notarize a document, I'm of the opinion, yes, you are well within legal and regulatory, the legal and regulatory framework to carry out an act of commissioning or notarizing, even though you're physically situated in another province. Again, this is what I call that white space that's in the regulations. It just doesn't say anything about this. And I would be of the opinion that you are a licensed professional regardless of where you're located. So I can be a lawyer, personally I am a lawyer, and I could be down in hopefully Dominican Republic in 2 months and commission a document either in person or remotely for someone who's either located there or elsewhere. Now, where you get into little, let's say, things you can step on your shoelaces or trip on is maybe that jurisdiction says, only BC notaries can sign documents in this province. So in this hypothetical, I'm not from BC. I don't know the regulations. I'm not aware of any that say that you must have a BC notary, as an example, notarize or commission a document in BC, and that a non-BC notary cannot. To pick up on BC really quickly, that's actually a very different legal and regulatory framework for notaries as compared to Ontario. It's much more similar to Quebec, where it is a separate professional accreditation, a separate professional class, and a separate educational stream to become a notary in and of itself. Whereas in Ontario, it's an appointment and an accreditation given out by the Ministry of the Attorney General. Do you want a follow-up, and then we? Okay.
In the jurat, you say that it's signed before we in the town of.
Yep.
So and so in BC, but you have to write but you can't say because I'm authorized to be a notary public in Ontario, in the city of Toronto. You cannot say that signed before me in Toronto. You have to mention that signed before me.
Yeah.
Say in Vancouver. You have to write that Vancouver, the location actually being signed at.
Yeah, so to sort of pick up your question and answer, the jurat must specify where you are physically located at that time, regardless of whether you are licensed in that other jurisdiction. And if there's anyone watching and has thoughts on this, I welcome any questions or emails later. It's an interesting discussion. And then I think we have maybe one final question here. Yeah, we're definitely on time.
My question is regarding security. So
say again, sorry.
My question is regarding security of the documents. When you notarize online, how do you ensure that the document, after you put the seal and you pass it on to the client, that they're not messing with the document? Do you just keep rigorous records of what was provided to the client, or is the document protected in a way where the client can't mess with the document?
Yeah, so how do we ensure the protection of the digitally signed document after a virtual commissioning? So, I mean, the quick answer kind of caveat is we don't know what happens fundamentally to that file after the fact. As a platform, and I would say this would apply to any platform providing the service, we do ultimately have the original copy, the control copy. We can always reproduce it at a later date. We could compare it to any future version of a PDF file that maybe is altered or amended or edited. However, the electronic signature audit log is embedded within the PDF file. It's part of there's a few different sort of technical requirements, but there's different certificates within the PDF file that when you open it in Adobe, which is sort of generally the industry standard for a PDF viewer and editor, there's the certificate record within the PDF file that will show that it has not been altered or edited from its original state. Just to pick up on that, one ultimate risk, I suppose, is clients who get a document digitally notarized or virtually commissioned, who then print it out and submit it somewhere. That does happen for many of our clients. We have no way, obviously, of controlling what someone might do with a altered PDF file. I could say thus far, in the tens of thousands of virtually commissioned documents Notary Pros provided, we've had no issues or incidents of any sort of fraud that have arisen later. And I think part of that is the fact that when you come and meet with one of our notaries, you are on a video call, you're meeting a licensed legal professional. I think there's a certain degree of respect and deference to the fact that you are swearing an oath at the time of the electronic signature. I guess we have either another online or we're one final, okay. That hopefully answers your question, yeah.
All right, so somebody online wants to know how to become a notary, what forms are needed, and what's the process?
Nice. Nice softball question to end it. So in Ontario, number one, you can reach out to us. We'd be happy to answer the questions. You could reach out to support@notarypro.ca. We'll help you figure that out. But in Ontario, you submit an application to apply to become a notary. You do have to be an appointed, a licensed a lawyer or paralegal already to apply to be a notary. There is a separate class called non-lawyer notaries. There's quite a few very specific circumstances in which you can get that non-lawyer notary appointment. I'm not going to dig into that, but for the most part, it's a simple application form. I believe it's a $75, $145. Okay, it's up. It's up. Everything's up. So, inflation, yeah. And so, yeah, you pay the fee, and usually you submit it by check to the provincial government. And I think it's like a 6 to 8 week wait. So if you are a licensed in good standing legal professional, you get the appointment. It is a lifetime appointment for lawyers and paralegals. Then you got to order your stamps and your seals and other gear that you'll need to be a notary. But it's pretty straightforward, and I don't really know of anyone having issues as long as you are a licensed legal professional. So with that, thank you so much, and I'm really pleased that everyone's here. Oh, and if you are willing and able, you're in the audience, we are going to host a little networking event right after this. And I think my colleague is oh, it's not on there? No, I thought there was another slide. But I'd like to invite Jaclyn from the Ontario Paralegal Association back on stage here. Thank you.
Thank you, Rob. That brings us to the end of tonight's program, and on behalf of the Education Committee and the Ontario Paralegal Association, I would like to thank Rob, Jaclyn, Talia, and Danny for tonight's presentation. Both educational and engaging. Your program was truly a masterclass on notarization for any type of document that your client brings you. And then finally, before we conclude, I'd like to announce that we do have an upcoming CPD in December, which will be presented by some speakers from the College of Immigration and Citizenship Consultants. That will be on December 6th, so just stay tuned on OPA online and our social media for more details. And for more information on this and other upcoming CPDs, please visit opau.ca to see what's coming up. So thank you again, everyone, for attending tonight's program. It was great to see you all in person, and have a great night.
Thank you.